Your Honours, I will address some core points relating to victims' standing and then turn to the first three of the Chamber's Group A questions. I will not be addressing question D in that section. It will be covered by Mr. Pietschak, and we agree with the submissions which he will make. On the question of victims' standing, the provision which must be construed is Article 82, paragraph 1, and in particular the words either party. The question, for your honours, is whether victims can ever fall within that phrase. The difficulty appears to be that it has now become received wisdom in this court that victims can never be described as a party to proceedings. And yet, the statute says this nowhere. The rules say this nowhere. And in fact, it has become normal at this court for victims to take some procedural steps which the statute or the rules reserve for parties. In our filing of 19 June, which is document number 50 in this case, we gave the example of Articles 64 and 69, which relate to the conduct of trial and the submission and challenging of evidence. But elsewhere in the text, other examples can be found where the word party is clearly intended, we say, to encompass victims. For example, Article 70, paragraph 1b, creates an offence where a party knowingly presents false evidence. Surely there can be no dispute that the term party in this context includes participating victims and their lawyers. Your Honours, we say it cannot be right that the term party includes victims where it imposes obligations, but can never include them where it grants standing. In the specific context of Article 82, paragraph 1 appeals, the ICC case law already demonstrates that the word party is not limited to the prosecution and defence. As already mentioned by Mr. Gaynor, the al-Bashir case allowed a state party, Jordan, to appeal pursuant to Article 82, paragraph 1. In the present proceedings, the prosecution has made submissions about the risk of genies being let out of bottles, leading to proceedings which are overwhelmed by interveners, including states. And yet, in the Bashir case, the prosecution made no objection to Jordan's standing to appeal under Article 82, paragraph 1. In paragraph 39 of their response to the victims' appeal briefs, the prosecution accepts that states can be parties with standing to appeal, where this is, quote, consistent with the broader procedural scheme of the statute. But they say that this approach is applicable only to states. No reason is given as to why victim standing is not likewise to be assessed in a manner, quote, consistent with the broader procedural scheme of the statute. With this submission, the prosecution implies, incredibly, that the Rome Statute intends to give a greater voice to states than it gives to victims. The Jordan referral appeal also shows that no weight can be put on the word either in Article 82, para 1. In that case, the proceedings included the prosecution and the defence, and the Chamber effectively recognised what is already clear from the language of the rules, namely proceedings can include more than two parties with standing to appeal. All of this serves to show, Your Honours, that there is no magic in the words either party. The meaning of those words must be established based on their context and on the statute's object and purpose. And this was the approach taken by the Appeals Chamber in the Lubanga case, when it held that victims can lead evidence and challenge the admissibility of evidence, despite the fact that the relevant provisions in the statute refer to parties. That's decision 1432 in the Lubanga case. The Chamber held that Article 69, which refers to parties, must be understood in context, namely, together with Article 68.3, which envisages a role for victims at any stage of the proceedings considered by a chamber to be appropriate. That's paragraph 98. And the chamber went on to interpret the relevant provisions in light of the spirit and intention of the statute, which it said is for victims to have a role which is meaningful and not ineffectual. And, Your Honours, this goes back to Mr. Gaynor's point regarding the need to interpret the statute purposively, and it demonstrates not only that this should be done, but that it has already been done by this court in respect of victims' role. In the present instance, there is a further crucial piece of context in addition to those which existed in the Lubanga appeal, and that is that Article 15 proceedings are the gateway to every form of participation at this court, as Mr. Gaynor has already explained. Your Honours, the prosecution says that recognising victims' standing would have disastrous consequences for the conduct of proceedings. Mr. Gaynor has already responded to the suggestions made about the risk of a flood of appeals. We will add one additional point, and that is to say that the prosecution's concern about the risk of parallel proceedings being launched by different participants, different parties in a proceeding, that concern is not specific and has no relation to the question of victims' standing as such. The possibility for parallel appeal proceedings to be initiated exists even in a proceeding which only involves the prosecution and the defence. Both would be able to appeal a decision, and it would be possible that one would use paragraph D of Article 82.1 and one would use another legal basis. I turn now to the Chamber's questions on which we make 2 points. Regarding question A, we agree with the 3 factors which Mr. Gaynor identified. These are relevant in deciding whether victims can appeal in a given instance. One of those factors is the stage of proceedings and the role which victims are given at that stage. This will be a particularly compelling factor in Article 15 proceedings, given the role that Article 15 proceedings play in determining whether any further subsequent proceedings can occur at the court. So we don't rule out the possibility of victims standing in other phases, but we say there is no clearer example of a decision which fundamentally affects victim interests than an Article 15.4 decision. Some brief comments on the relationship between appellate standing and standing at first instance.
Counsel, you have 2 minutes left.
Which is the question raised by both questions B and C in Group A. And the prosecution has today submitted that one of the reasons that they say the prosecutor only can appeal in Article 15 proceedings is because only the prosecutor can initiate such proceedings. However, standing to appeal is not limited to parties who could have initiated proceedings at first instance. No such limitation is found in comparative law. No such limitation is found in the statute or the rules. To give one very clear example, only the prosecutor can request an arrest warrant. Nobody contests that the defence may appeal a decision which issues one. The Jordan referral appeal provides another example. A state party cannot initiate Article 70 proceedings. Nonetheless, a state party was permitted to appeal the resulting referral. This is not to say that first instance standing rights are irrelevant, rather to say that the role of a party at first instance is one factor which can be considered in determining whether that party subsequently has rights of appeal, as explained by Mr. Gaynor. Your Honours, the creators of this court intended to lead the way in giving victims a real voice in international criminal proceedings. Since then, 2 international criminal courts, the STL and the ECCC, have recognised that this real voice entails allowing victims a right to appeal in some circumstances at least. This court is now in danger of falling behind. Your Honours have a chance now to correct that and to ensure that just as the drafters intended, victims can be heard on the issues which matter most to them. Thank you.